Okay, students, my name is Mark McDaniel, and I will be your instructor in this class, BLS 211. It will not be my job here to make all of you lawyers. Hopefully at the end of this class you'll have a good general understanding of business law. Enough, I hope, to where when you're in business and you have some kind of problem, you'll say, well, I might need a lawyer, and call a lawyer. If I do that, Congress said I've done my job in this class. I'll first of all tell you that, you have your handouts, you have a textbook, and it's a very good textbook. You can follow along with my lectures in the textbook if you want to, but you have the handouts, which will be posted there. The lectures will be taken from the handout. Your examinations will be taken from the handout. As I give you through some of these lectures, I'll go through some of the test questions with you. As I go through the lecture, I'll give you some of the test questions so that you can kind of see exactly what, here was the lecture, here's the outline, here's the test question that's on that covers that. So most of just about all your tests will be taken from the handout here. Hannah Wilkes, who's my senior paralegal, will be helping me in this class. Sometimes I say case. I've been practicing law 48 years. I've been lead trial counsel well over 100 jury trials and over 1,000 non-jury trials, well over 100. I've quit counting, but 48 years I've tried a lot of cases, including Governor Guy Hunt's case when he was indicted. I've represented a lot of public officials. I've done many murder cases, just about any case, civil cases, domestic cases. We'll talk about some of those as we go through. Give some examples in my lecture. I'll talk about some of the cases that I have tried. But Hannah Wilkes will be helping me in the class, and if she posts something, if you ask her a question and she answers it, it will be just as if I answered it for you, because she has that authority, and she works very close with me every day. So now we'll go into the lecture, and then we'll just do some of the test questions so you can see how this class is going to unfold. I really do want everybody in this class to make a good grade. I think anybody that's had me before at UAH or any other school, law school, or anywhere I've taught, knows that I want to learn a little something, and I want you to make a good grade in this class. And so whatever I can do to help you with that, I'll do that. Okay? So let's look at our outline real quick here, and you see that you have your notes there in front of you. You see your first term there, stare decisis, means stand by the decision. Well, that's pretty easy now, because that's the word precedent. You've heard the word precedent. Like if a person gets arrested and you've heard about them, did you read them their rights? We'll talk about that some more in a later lecture. But that's called Miranda rights. Now, there's nothing in the United States Constitution that talks about Miranda versus Arizona, but there is a Fifth Amendment which says that a person cannot be compelled to be a witness against himself. So before you can use a confession, a statement against a defendant in a criminal case, the law enforcement officer must first advise him of their rights, the Miranda rights. Must say you have a right to remain silent. Anything you say can and will be held against you in a court of law. If you cannot afford a lawyer, one will be appointed for you. Do you understand these rights? And with the knowledge of these rights, do you wish to make a statement? We'll talk about this later on, of course. That's the Miranda warnings. The police officers or investigators read that if they're going to use a person's statement against them at trial. Put it into evidence, if you will. That's a precedent, the stare decisis. That's the law. The Supreme Court says it's a law. Now, we know really, really good about precedents right now, because we had Roe versus Wade, which was the law for many years. Now we have the Dobbs decision, which changed that. Now, why is that? Because the United States Supreme Court says it so. The United States Supreme Court, when they make a ruling, that is a precedent. The United States Supreme Court justices are appointed by the president, confirmed by the Senate, and they have lifetime appointments. All federal judges, U.S. district judges, U.S. appellate judges, and United States Supreme Court judges, all federal judges have lifetime appointments, okay? So anyway, so you know what a precedent is. Now, you have the perfect example of that, and also in affirmative action issues. And we won't go into all those right now, but we will go through a lot of those during this class. Right now, we're just getting kind of an overview, an introduction, if you will, first couple of chapters in the book. Let's look at substantive law versus procedural law. Substantive law is the law itself. The substantive law, like if you go to law school and you take a class in criminal law, you will study the elements of the crime, okay? We'll talk about like murder in this class when we talk about criminal law. In the substantive law for murder in the state of Alabama, 15A62, says a person commits a crime of murder if they intentionally cause the death of another person. So in Alabama, what do you have to prove for murder? You have to prove that a person intentionally caused the death of another person. All right. Now, in Tennessee, in Georgia, in Florida, in Mississippi, you have degrees of murder. You have first-degree murder, second-degree murder, first-degree manslaughter, second-degree manslaughter. You do not have that in Alabama. You have murder, manslaughter, and criminal negligent homicide. So when we talk about the substantive law is different from state to state. So for instance, in Tennessee, to convict a person of first-degree murder, you have to prove that there's a killing of the person with premeditation and malice aforethought. Premeditation is a lying in wait, if you will. Malice aforethought is a fixed hate, ill will, desire to hurt. Now, by the way, you get these terms, aren't you? That's one thing I'm going to keep stressing all during this class. This is not mathematics. This is not physics, okay? You're going to hear terms like reasonable doubt. You're going to hear all the reason. You hear it so many times, reasonable. What is reasonable? You're going to hear, like in self-defense, a person can use deadly physical force if he reasonably believes the other person's using or about to use unlawful deadly physical force against him if he reasonably believes. What is that? That's what the jury thinks it is. What 12 people says it is. The judge will define it, but it's what the jury says. So anybody that says, now, Mr. McDaniel, I want you to do better than that. I want you to put a formula up there in some kind of something to show me, some kind of PowerPoint here that shows me exactly what this is, like 1 + 1 is 2. No, I can't do that. The person testifies at court. You got a jury. You got a lawyer cross-examine. You've seen enough shows to know what it's like. So that's what I spent my life in the courtroom. Okay, I'm not a patent lawyer. I'm not a copyright lawyer. I don't make my living that way. A lot of good patent lawyers, copyright lawyers, and the like. I've made my living in the courtroom. And so, anyway, as we go through, and you say we get these terms, you're going to say, what is? Well, it's what a jury says it is. Okay, so the substantive law is the elements of the crime. Okay, so again, the elements of murder in Mississippi, in Tennessee, in Florida, in Georgia are different than in Alabama, because you have to have second-degree murders, killing in those states, killing another person with malice aforethought. Okay, you don't have to premeditation. Now that's those states. The other states, Alabama, murder is a person commits crime, murder. If you intentionally cause death of another person, don't require premeditation, malice aforethought. That's the substantive law. The substantive law in a tort case, which we'll get later on, a civil case, a tort action. Substantive law for that would, what are the elements of a negligence cause of action? If you run a red light and you hurt somebody and they sue you for negligently running that red light, they got to prove a duty of care, breach of the duty of care, and the proximate cause damages. The proximate cause of the which you were damaged in that car wreck. The other person was, that is. You're the one that ran red light, you hurt them. They got to prove that against you. The substantive law. We're going to have a whole lecture on torts, and so we'll talk about negligent torts when we get there. You don't have to learn that at this point right here, okay? But we're just talking about the substantive law, okay? So when you take You go to law school, you'll take a course in criminal law, which will be the substantive law of the elements of crime, such as burglary, robbery, rape, arson. Elements. What does the state, what are the elements? What does the state have to prove to convict the defendant? Okay? Now, let's go into procedural law. Okay? That is the process that you go by. All right? For instance, and when we talk about criminal law, we'll talk more about this. The procedure in a criminal case is the arrest, the felony examination, first appearance, preliminary hearing, the grand jury, arraignment, and the jury trial. Okay, that's the procedure that you go through. I did that in 10 seconds, but it may take 4 years to get to it. If it's a capital case, it may take longer than that. But anyway, that's the procedure in the case. When we talk about a civil case, you'll have a complaint. If you sue somebody, you'll file a complaint. They'll file an answer. Then you'll have discovery. That's your depositions, interrogatories, motions to produce. You go through your procedure. So the substantive law is the law itself, and the procedure is just the process that you go through in the case. So substantive law and procedural law. Let's look at jurisdiction versus venue. Jurisdiction is defined as the power of the court to entertain the action. Jurisdiction may never be waived nor conferred by the parties. Jurisdiction, okay, let's look at Alabama now, the Alabama court system. You got district judges and you got circuit judges and you got appellate judges. The district judge in Alabama in a criminal case has jurisdiction to hear misdemeanor cases and do preliminary hearing in felony cases. That's the jurisdiction of a district court judge. A circuit judge has jurisdiction to have jury trials in the criminal cases, in all cases, misdemeanors and felonies. That's where you can have a jury trial. You cannot have a jury trial in district court. Why can't you have a jury trial in district court? Because district judges don't have jurisdiction. Again, jurisdiction is the power of the court to entertain the action. The jurisdiction may never be waived nor conferred by the parties. So if I was, let's say that I had a murder case, I was defending a murder case, and I go to the prosecutor and I say, look, let's try will you stipulate and will you agree that we try our murder case, which is a felony case, in front of Judge Coates and have a jury trial with Judge Coates. She's a district court judge, very, very good district court judge. You agree to that? And if she says, yeah, well, I agree to that, okay, and we go to Judge Coates and we say, Judge, we both agreed that we want to have a jury trial in your courtroom. Let you be the judge. And she's going to say, I can't do that because I don't have jurisdiction. I'm a district judge, not a circuit judge. So the jurisdiction may never be waived nor conferred by the parties. We can't agree to it, and because that judge don't have jurisdiction. She has jurisdiction in criminal cases to do misdemeanor trials. That's without a jury. You have, like if you get a DUI in New Hope, you'll go to New Hope City Court. Now you can appeal anything happens there in New Hope City Court. You can appeal it to circuit court and get a jury trial. Right? Just if you get one in the city of Huntsville, you go down to city municipal court down here, and you'll have your case. You won't have a jury there. You have a city court judge. You won't have a jury, but you can appeal that and get a trial de novo, new trial, in circuit court if you want to appeal, if you don't like what happened in the city court or the district court, okay? In civil cases, the district judge has jurisdiction up to $10,000 with no jury trial. You cannot have a jury trial in district court, only circuit court. So that's jurisdiction, okay? Venue is the place where the action may be tried. Now, you can't get a change of jurisdiction, but have you ever heard the term change of venue? You have, hadn't you? Because the venue is the place where you try the case. Now, it can be changed. If the defense lawyer can show that she can't get a fair and impartial trial in a certain area, then she can get a change of venue. Now, that's hard to do, but I've got to change the venue in some cases. When I represented Governor Hunt, I tried to get his case moved to Coleman County, but the judge said, does he live in the governor's mansion? I said, well, yes, sir. He said, well, we're going to try him in Montgomery because that's where he lives. So we had to try it in Montgomery. But you can get a change of venue if you can prove, especially these high-profile cases. I've had some very high-profile cases, and we had recently did this Casey White case where Vicky White broke him out of jail, and they was on the run for a while, and then when they were caught, she shot herself. And he was charged with 2 different murders, and we got both of those murder cases dismissed, and he pled to escape, which is what he did. But I've had some very high profile cases. You have these different places come in from over the country and do shows and stuff like that about them. But I've had a number of those cases in my career. But anyway, but sometimes you have cases where you have the profile. If you try the case, like if we had to try that case and hadn't worked that white case out, there's no way we could have tried that case in Lauderdale County. Everybody in Lauderdale County, we'd probably have to go to Mobile and try it if we'd ever tried it. But we got it resolved, we got a plea bargain, so we got both murder cases dismissed, pled him to the escape. So we didn't have to have a trial because we had a plea bargain. Got it done that way. So jurisdiction, venue simply the place where the action may be tried. All right, let's look at civil cases versus criminal law. Okay, now a civil case is where you're suing somebody or somebody's suing you. You're suing a corporation suing you. You're suing the government, whatever. It's a civil case. If you have a car wreck, all right, and somebody hurts you, you're going to file a lawsuit. That'll be a civil lawsuit, okay? A single act can be both a civil act and a criminal act, by the way, okay? If I walk up to you and I hit you, okay, and break your nose, can you sue me for that? That's a civil case. Can you sue me? It's an intentional tort. Can you sue me for that? Answer, yes. Can you also get me arrested for that? Yes, okay, because that's a criminal case and a civil case. If I'm drunk and I run a red light and I hurt you, okay, or let's suppose I run a red light and I kill somebody, okay, will I get sued for wrongful death by the family? Absolutely, that's a civil case, the lawsuit. Will I also get arrested for reckless murder? I sure will, okay. They can prove I was intoxicated, running a red light or stop sign or whatever. Okay, now we'll talk about that when we get to criminal law, maybe murder, manslaughter, criminal agent, homicide. Be charged with murder, but we'll talk about that when we get to the criminal law class. Okay, but we're talking about a civil and a criminal case. Civil law is where the parties are going against you. It's a civil case, suing for money. If I owe you, if I sign a promissory note to pay you $50,000 and I don't pay you, you're going to sue me for not paying that. That's a civil case. Okay, the criminal case, of course, is where it's me versus society. The society says, certain things are crimes, certain acts are criminal acts. Now, different states have different criminal laws, by the way. Okay, the legal age of consent for sex in Alabama is 16. Tennessee, it's 18. Okay, so what you can do in Alabama that would be legal would be 20 minutes up the road here, you go to prison for 20 years, okay? By the way, don't think if you bring a girl from Tennessee down to Alabama and for the purpose of illicit relationships, let's say, you can't get out of it by saying, well, she was 17, but well, she was in Tennessee. It's against the law. You brought her down here, and that's a violation of the Mann Act. That's a federal crime, okay? So they get things covered by that. But you can see the law is different. The criminal law is different in different states. Some states, possession of marijuana is legal. It is not in Alabama. Some states, gambling is legal. Some states, not legal. Okay, so you have to check with the law in the state where you're at to see whether or not this particular crime this act would be a crime or not. Okay, so anyway, that's the criminal law and the civil law. Next note, you see distinguish law and equity here. All right, law. If you're just doing a chart, I want you to say law over here, and I want you to put jury trial and money. So if I'm suing you, if I sign a promissory note to pay you money, and I don't pay you, you're going to sue me for money, aren't you? So we'd be in a court of law, and in a court of law, we have strict rules of evidence. All right. We have what's called statute of limitations. We'll talk about that in a minute. That's the period of time that you can sue somebody, and if you 1 day late, you're out. It's called statute of limitations, time limit you've got to sue somebody. The rules, again, the rules of evidence, we'll have electoral evidence in this class. The rules of evidence are real specific in the court of law. So that's law is again, jury trial and money, kind of keep that in your head. Now, equity. What is this equity? Well, if I'm in a divorce case, okay, if I file for divorce for somebody, is the jury going to make that decision about who gets custody of the kids and alimony and stuff? No. The judge is going to decide that. That's in a court of equity. There is no jury trial. Okay, the judge makes the decision. All right. So let's look at some equity matters. Okay. So the domestic relations, we just talked about that. That's an equity matter. All right. Specific performance. If I sign a contract to buy real estate, okay, let's suppose I agree to sell you my house for $750,000, and we sign a contract for $700,000, and I get somebody else calls me and says, look, I'll give you $750 for it, and I'll call you back and I say, look, I got somebody else going to pay me more money for that. I'm sorry, and here's your earnest money back. Well, you don't have to do that. You can sue me and make me go ahead and do the contract and sell the property because we have a contract, and that's specific performance. You can sue me for specific performance and make me do the contract. Injunction is something, and by the way, a judge makes that decision. The jury don't decide it. If I want an injunction against somebody from doing something, if I'm living in, let's say I live in a commercial, residential area, and I go home tonight and my neighbor's digging a hole in the backyard. Go home next night and there's water in that hole. This is a residential area. Wherever you live, let's say you're in a resident, not in a country, but residential area. Hole there. All right. And there's water in the hole. And you go home the next day and there's a bunch of hogs in that hole, wallowing around. Well, you're in a residential area. You want them hogs being in you? Do you want them hogs being next door to you? And if ever live next to a hog parlor, you wouldn't want that. All right. So you'd want an injunction. You'd want that removed. You'd want that nuisance, they call it, nuisance removed. Now, the jury's not going to decide that issue. A judge is going to decide that issue. If it's a domestic relations case and there's been a domestic abuse and you want one of the parties wants the other out of the house, a jury's not going to decide that. A judge is going to decide whether or not to enjoin that person from coming back home. If I go home tonight and there's a deputy waiting at my house at 10 o'clock tonight and gives me a paper from the judge that says you can't go in this house, I've been enjoined from going into that house, I can't go in the house. If I go in the house, I'm going to go to jail because I violated a court order. Okay, is that a court of law do that or a court of equity do that? Will the judge be the equity judge or law? That's equity. That's an equitable issue because the jury don't decide that, do they? It's not about money, it's about getting me out of that house. If it's a nuisance, it's about removing that nuisance. Okay, so that's another thing to be equity, injunction. What about something priceless, unique, and one of a kind? That's another thing. Priceless, unique, one of a kind. Suppose your grandmother dies and she leaves you the engagement ring. It's a little diamond engagement ring that your grandfather gave her when they got engaged. Well, you have a ne'er-do-well relative, and we all got them, okay? And that relative gets that ring before you get it. And you go to a lawyer, and you say, lawyer, my grandmama left me this engagement ring that my granddaddy gave to her. She wanted me to have it. And my niece, or one of my relatives, got it over here. All right. Lawyer said, well, what's it worth? And you say, well, it was a small ring, a small diamond in it, maybe $500, $1,000. And the lawyer said, well, you go down to small claims court, file your small claims court action and just get money back from the person. Is that what you want? You want that $500, or you want that ring? You want the ring, I hope. So you go into the court, you go in and you file an action for the ring. That's a court of equity. That's an equitable issue. You want that ring because that ring is priceless, unique, and one of a kind. There ain't that's not another ring like that one. That's the one you want. That's when we talk about specific performance a while ago in real estate. The reason the judge is going to make you sell that real estate in that real estate contract once it's signed is because the law says every piece of real property is priceless, unique, and one of a kind. That's the reason you do it in equity. Okay? So again, you got some ideas about equity there. You're getting, like we said, about domestic relations. That's an equitable issue. Juries don't decide custody, do they? So if it's money, then you have a jury trial. If it's a car wreck, something like that, jury trial. A promissory note, somebody owes you money, jury trial, go to court of law. Now the rules of evidence are a lot different in court of equity. If you're in a child custody issue and there's some kind of hearsay, that's hearsay is the unsworn to uncross-examined statements made outside to prove the facts that are inserted. All right, and there's some kind of hearsay that would never be admissible in court of law. But we're in a court of equity and there's no jury, and the judge wants to decide what's in the best interest of this child, where this child is going to spend the rest of her life, or her during the time of minority, when she's a young child, a young person. The judge may say, I want to hear this. All right, and that's okay. Now the statute of limitations, we talk about statute of limitations in law, the term in equity is called laches. Okay, the equivalent of statute of limitations, which is on the law side, it's real strict. It's like you have 2 years to do this or 6 years to do this, and it has to be right. If you one day late, it's over. Not in equity. Equity determines laches, and that just says the court aids those who are vigilant, watchful, and faithful in their affairs. If you let something go on for a long time and you say, well, it's a nuisance, well, the judge is going to say, you let it go on that long, it's not a nuisance. You let something go on long enough, the judge is going to say, well, no, you wouldn't, you let it go on, okay? So statute of limitations on the law side, latches on the equity side. There is no specific time, by the way, when you're talking about equitable issues. Latches, you just got to be, there's that word reasonable, okay? All right, so there we've got that down, law and equity, statute of limitations. Like we just did that. Equity, okay, we just talked specific performance, injunction, domestic relations, we did that. All right, look at number 8 there now. A lawsuit is started by filing a complaint. Now, if somebody hurts you or somebody owes you money, you go file a complaint. That's how a civil case starts. A criminal case starts with an arrest or a grand jury indictment. That's how a criminal case starts. We'll talk about that later on. Civil case starts by you filing a complaint. Now, what do you do if you get sued? You get a complaint and you get sued. All right? What are you going to do? Throw it in the garbage can? Or are you going to say, you're going to answer it? Now, you better answer it. Now, if you don't get anything else out of this class, if you ever get sued, answer the complaint. It can be just as simple as this. Comes now defendant herein and denies all the plaintiff's material allegations in the plaintiff's complaint and demands strict proof thereof and sign your name and you got it answered. Okay? If you don't file an answer in that complaint, you're going to get a default judgment against you. How many times we got lawyers in the firm here that do domestic relations cases, and you get these people come in and they say, a lot of times it's a man, and he'll get his wife is suing him for divorce. All right, and the lawyer, he brings in this, says judgment by default. He brings that in, hands it to the lawyer and says, lawyer, I got this right here. Says judgment by default. And he's lost his house, he's lost his car, he's lost his kids, he's lost his dog, he's lost his cat, everything. He's lost it. All right? Now, the lawyer says to him, well, did you get a complaint? Did you get a complaint? Your wife filed a complaint against you? Yeah, she filed a complaint against me. Well, what'd you do with it? I throwed it in the garbage can because I wasn't going to give her no divorce. Well, it ain't no matter giving her no divorce. That's when I was in law school, Started, like my daughter says, in 1840, but it wasn't. I went to law school from 73 to 1973 to 76. But my daughter, she said when she's young, she don't say it anymore. But anyway, so if you don't answer the complaint, you're going to get judged by default. And that man wouldn't have lost all that if he just answered the complaint. If you get sued, answer the complaint. And don't think it's going to go away, because the other side's going to get a default judgment, and they're going to get more than they asked for. You're going to get lawyers' fees and all kind of stuff. If you just answer it and go, and if it's small claims court or whatever, we'll talk about something like if you have a lease and you leave before you pay your rent and you get sued. There's ways you can get the damages reduced, and we'll talk about that when we talk about contract law and real estate law. We'll talk about how that works, how you wouldn't have to pay as much as you get sued for, but you got to answer the complaint and go to court, and usually can resolve it for a whole lot less than you get sued for. So again, answer the complaint, just a simple answer in your pleading there, okay? All right, in number 9 says if an appellate court affirms a case, it's upholding a case or agreeing with the lower court. All right, so let's suppose I'm trying a murder case, lose the murder case, appeal the murder case, and I get my decision back from the Alabama Court of Criminal Appeals or Alabama Supreme Court, and some lawyers go right to the last page. I read the whole opinion. I don't turn the last page. You can turn the last page to know if you won or lost. So let's say it's a 30-page opinion. You go last page, you're the defense lawyer, you appealed it. It says affirmed, and it means you lost, because they uphold what happened in the lower court and the circuit court, and your client's got to go ahead and serve time, whatever. You lost, okay? So the prosecutor won, the defense lost. You won the appeal, it says affirmed, you lost. Now, what if it says reversed and remanded? If it says reversed and remanded, that means I get another shot at it. It means it comes back to court, and the appellate court's told the lower court, you made this decision, was not a correct decision, whatever the evidence or whatever, and your client gets a new trial. Okay, all right. So that's what you like. So if it says reversed and rendered, that means the appellate court, you won the case. There wasn't enough evidence to even try your client. But affirmed means it was the lower court was upheld. You lost if you was the one doing the appeal. If you were the appellee, the appellant's the one in the appeal. The appellee's the one that's answering the appellant's appeal. So if you're the appellee, you won. If you're the appellant, you lost. If it's affirmed, if it's reversed and remanded, then it's exactly opposite of that. Okay. So again, when you start, you people, there are going to be some people watching this. I promise you this. There are people watching this right now that's going to be lawyers someday. I promise you. This many students, I guarantee you, they're going. So you'll get those opinions back, and you'll think, well, do I want to look at the last page and see if I won or lost, or I just want to, let this thing, see where we're going. Anyway, if you turn the last page, you'll find out real quick if you won or lost. All right, let's see here what else we got here. Let's see, your number 11. Okay, let's remand. Okay, number 10. If the appellate court remands a case, it sends the case back to the lower court. We talked about that. Number 11, a convention. There's some parts of international law in your chapter, so I just throw these in there. A convention is a law adopted by an international organization that was created by a treaty, like the United Nations. NAFTA is an example of an agreement. These are relationships made between heads of state. Now we'll go into some of the ethics in this lecture here. But before we do that, let me look at a few of these test questions we got here. Now look at your outline here, and let's look at a few of our test questions here. Okay. All right. Now I won't go over all of them, but I just want you to see how your test is going to flow here. Okay. So this is the test. This is your first test you'll be taking. Okay. So here's a question. Known as the doctrine of stare decisis, the judge uses a blank. That is, decision of a previous similar case to decide the outcome of the current case. A, precedent. We don't have to go no further than that, do we? Because that's the answer, A. All right. Okay, another question. The rule of stare decisis serves which of the following functions? A, it allows the court to be more efficient. B, it results in a more just and uniform system of decision making. C, it makes the law more stable and predictable. D, all the above. Answer D. All right. Another question. These are the exact questions now. They're not like them. This is the questions on the test, okay? This type of law defines, describes, regulates, and creates legal rights and obligations. A, procedural. B, public. C, contractual. D, substantive. Answer D, substantive. Okay. All right, let's see. A court of blank generally grants money damages award. A, equity. B, legality. C, law. Answer is going to be C. These none of the above, but answers is C, law. Okay. A court of blank generally grants a remedy. Another question. A court of blank generally grants a remedy rather than a money damage award, which is a legal means to enforce personal rights to correct a wrong. A, equity. There's your answer, isn't it? It's rather than money. If it's not money, it's going to be in a court of law, okay? In a court of law, the limitations set for filing a lawsuit are called A, the doctrine of laches. B, the doctrine of time constraints. C, the doctrine of counter constraints. D is none of the above, and the answer is number 7 is D, none of the above, because it's the answer statute of limitations. Kind of a tricky question. I don't know why I put that in there, but I did. All right, let's see here. A plaintiff may ask a court to issue a decree of blank that orders the defendant to perform the acts that he or she promised to do in the contract. And that's, A is rescission, B is specific performance, and the answer is B, specific performance. We don't have to go further than that one, okay? All right, if a court blanks a case, it is upholding or agreeing with the lower court's decision. A, reaffirms. B, affirms, which that's going to be the answer to B. All right? All right, so you see kind of how this, hope you see how this kind of flows here. And, you know, you just, again, what you'll do is you just follow my lectures, and that's the test you'll see there is going to be taken right from so I just went over some questions there. So let's go over the rest of the lecture, this first lecture here, and this is your chapter on ethics here. All right. And you see the term teleology there, evaluates the morality of an action on the basis of its consequences. Okay? Basis of its consequences. So teleology says this: the morality, again, this is moral philosophy, if you will, ethics. All right. By the way, I've taught for many years, law, ethics, and business, and business ethics, if you will. And how do you teach ethics? It's like teaching how to hold the air or water. Okay, you can define it. You can read the book. You can look up and Google it, and you can read all about the definition of ethics. Does it make you ethical? Open the book. Open your newspaper every day. Y'all don't have a newspaper. Well, I still get a newspaper. Y'all got your computers, and you open it up every day and look at the news. And you're going to see some politician or some business executive, somebody ought to know better, violating the rules of ethics, aren't you? My 48 years, I've never had anybody, represent a lot of corporations in trouble, but I've never had anybody call me up and ask me, is it ethical? Never. They ask me, is it legal? Can I go to jail, prison for doing this? But they never asked me. We teach all these classes in ethics, and that's good, and we should. We should be more ethical, virtuous people, if you will. But I've never been asked that. I've been asked, is it legal? Can I go to jail for this? If our company does this, they don't ask me, is it ethical? Okay. So what is this? What is it? My grandma, Mom Mac, told me, she said, son, you know if it's right, you feel it in your stomach. I know Mom Mac was telling me you got a conscience. Now, some people don't have one. I've represented serial killers, and they don't have a conscience. They're called sociopaths. And I've represented some. I may talk to you about it. some situations, in some instances, and I've represented some serial killers in my career, and they're sociopaths. They don't have feelings for other people. They don't have empathy. They love themselves. They just want for themselves. Whatever makes me feel good, that's it. Okay. So anyway, this thing called ethics, we'll go through a few terms here, and we'll try to get a little bit of it. But I will say this about ethics: a good night's sleep. But I'm representing some people right now, very powerful people, very wealthy people, but they're not getting a good night's sleep tonight because they're worried. They got grand jury subpoenas. They got things they're worried about, and they're paying me a lot of money to represent them. But they're not sleeping good, and a good night's sleep is worth a whole lot. Freedom's worth a whole lot. Health and freedom worth a whole lot there. So teleology. All right, we talk about teleology, evaluate some morality based on the consequences. All right. So let's talk about utilitarianism. It comes under teleology, utilitarianism. Utilitarianism says that the morally right thing for you to do is that act which benefits the greatest number of us. Jeremy Bentham, a great philosopher, and talk about that. So utilitarianism, the morally, that's a big word. It's again, you can look it up and define it, but I think if you've got it, you either know it or you don't know it. Okay, and you can't teach it. All right, the morally right thing for you to do is that action which benefits the greatest number of us. Now that's okay if I'm in that greater number. But what if I'm not in that greater number? What if I'm in the minority? Then that's not a good rule for me. Okay, you say, well, this rule here, it's morally okay. It's right if this action benefits the greatest number. If we got a business and I can pay, let's say I'm a CEO, and I can pay a bribe in the morning, I meet some person in the morning, I can pay that person a bribe, and we'll get a contract next week, and we'll stay in business. Now if I don't pay that bribe, we're not going to be in business next week because somebody else is going to get the contract, and we ain't going to get it, so we're going to go out of business. Now, a utilitarian would say, pay the bribe. It helps the greatest number of us. It helps our company. Now, I may go to prison for it, but if you go by that philosophy, then the morally right thing for you to do would be to do that act which benefits the greatest number. You can take that to extreme. It could be, murder could be okay. You could kill many people if you say, and you could go back and use your imagination back in history, back in the Second World War, millions of people were killed, and it benefits the greatest number of us. Now that's illogical and it's wrong, but that's a philosophy there. The ethical egoist. Now that's, you've heard egomaniac, haven't you? The ethical egoist would come under teleology. Under that philosophy, under the ethical egoism, okay, the morally right thing for you to do is that act which benefits me. All right? I got the way. I know the way. I got it all figured out. You just follow me. If you follow me, you're going to be in good shape. You're going to make money. You're going to have a good life. Everything's just going to be great. Just send me your money or whatever. That's ethical egoist. All right, ethical egoist, the morally right thing for you to do is that act. If I'm an ethical egoist, which I hope I'm not, but if I am, or if I were, then the right thing for you to do is that act which benefits me. Not you, but me. Okay? So it's not the act, it's the consequences. The consequences, that's teleology. The morality is determined by the consequences of the act. All right, teleology. So you have that under there. You have you got deontology. Again, when we talk about utilitarian egoism, ethical egoism, deontology. Now let's look at deontology. Deontology says your handout focuses on the rights of the individual and on the intentions associated with a particular act. All right, teleology. The morality is determined by the act, not the consequences. Okay? It's not good to lie. Okay? Now, according to a deontologist, if you lie, that's morally wrong, according to this philosophy. Now, if you go back into utilitarianism, ethical egoist, whatever I tell you to do from ethical egoist is okay. It's morally okay. But under deontology, the morality is determined by the act, not the consequences. Thou shalt not. If you do it, it don't matter if you get caught. It don't matter what the consequences are. If the consequences are bad, you just shouldn't lie. Okay? Thou shalt not, do what you shouldn't steal, whatever. Okay? The morality is determined by the act, not the consequences. All right, Immanuel Kant, he's a great, great German philosopher, and that was what he talked a lot about deontology. And he came up with a categorical imperative, and his categorical imperative is if you wake up in the morning and every act that you do becomes a universal law of nature. Immanuel Kant said you would act different because you would not want what you do binding on your children, on your grandchildren, all for a universal law of nature. You would act different if everything you did was a universal law of nature, binding on everybody from here on out. Okay? And that's what his categorical imperative is. That you would act different if it was binding on everybody from here on out. Again, these are just philosophy. You can agree or not agree or whatever, but I mean, there's so much more there. It says like 15. Are examples the categorical imperative, Golden River examples of deontology. Again, the morality is determined by the act, not the consequences. Some people say it. What Kant. This has been brought up. What if you had some people hiding from the Nazis, and somebody comes to the door, the SS comes to the door and knocks on the door? Do you have anybody in here? And should you lie about it? Or should you tell the truth? So, we'll talk about that next situation. I can't tell you. That's something every individual has to decide. I would say if they got them in the house, and they're I would say doing the right thing, and I'll let you decide what you would do with that. But anyway, so the morality is a big word, and what's right and wrong and ethics is a big word. Let's go to the next thing. And 16, an individual who believes that an action is ethical because others with her company and industry regularly engage in this activity is probably a relativist, a moral relativist. Moral relativism is just simply this: it's our group says this is the thing. Suppose you go to work for a new company, and the person comes to you and they say, this is the way we do things around here. Well, you may be like Mom Mac told me, you don't have a good feeling about that. That ain't right. Okay, but that's the way we do things around here. All right. Now they say it's right. That's an example of moral relativism. It's okay for us. Now you may get into a situation. You have situations where the cultural relativism, where it's okay to do something in one culture, and it's not okay to do another. That's moral relevancy. Okay. So that's you get into cultural issues, and you get into all kinds of things when you get into the moral relativism. Montesquieu, a great philosopher, founding fathers relied on him to a great extent. He taught a lot about legal relativism. what is legal in one place may not be legal in another. And I talked to you about that, about the law in Alabama and Tennessee, in legal age of consent. 16 in one state, 18 in another state. Do something down here it's legal, 10, 20 years in prison, 20 minutes up the road here, okay? So legal relativism. Montesquieu, if you want to read about that, he's a good person to read on that. All right, let's look at, I don't know if we have virtue ethics in here or not, but we should talk about virtue ethics is a really interesting thing. I don't think it's one of our things here. But virtue ethics is simply that morality is determined what a virtuous person would do under those situations. The only problem with that is who's that virtuous person? Who is this? Who is this? We can look it up. Now, teacher, you need to tell me what a virtuous person is. You're my teacher now. You need to tell me tell me about this virtuous person, who this is. Well, we can define it, but, founding fathers assumed that everybody, voters, were going to be virtuous. And that they elect people, have a virtuous people electing people. You can agree or not agree whether that's the case or not. But it's like morality. It's what I think about virtue may not be what you think about virtue. So I'm sitting here and tell you, I don't have all the answers. That's another thing too. I have to tell you, the older you get, I'm not a young man anymore, but you can tell by the way I'm moving around in my chair. But the older I get, the less I know. I don't know what that is. But I thought, one time in my life I had it pretty well figured out. John Paul Sartre said everybody wants to be God. I had never thought I'd reach that level and didn't never desire to, but that's what he said. But I just don't. I think you're looking at maybe looking at the least judgmental of a perfect human being. I don't go around judging. That ain't my job. I represent a lot of people who've been in trouble, and people. What I have found out is there's some, I'm not talking about violent crime, I'm talking about money, fraud and ethics problems, stuff like that. That I see some good people who just made bad decisions. Good people, good family people that try to do right, but they go out here and they make a mistake. They'll do something, make a decision, just over maybe an hour, even less time than that. I represent people in murder cases that decided, less than 5 seconds. Those acts of violence are just so quick. When we talk about criminal law, we get in criminal law lecture. We'll talk about that. But anyway, let's look at this situation. Virtue ethics, that's another thing. But I don't think I have that in there. But so there'll be no test question about that. But I thought it might be. But I'll try to cover it. I'll cover everything in here. All right, look, number 17. All right. Situational ethics states that every situation is unique and consequently moral rules and other guides are either useless or of limited value. Situational ethics. Now, these are all, if they're on here, if they're on this outline here, there'll be a test question. You know exactly how it's going to go because I've read some of the questions to you. All right, so you know exactly how it's going to go. You just count on it. That's going to be there. Situational ethics is this. Is it your legal guides or your moral guides? If you got that, if you've got an ethical guides or whatever like that, they are of limited or no value at all, depending on your situation. Not my situation, but your situation. My situation, I started practicing law at 24 years old and I was poor, about as poor as you could be, all right? And I came out and had nothing. And I started practicing law, all right? Now, what kind of human being would I be now? I've been practicing law 48 years. If I said, well, young lady, you shouldn't do this. Well, when I was 24, it was different for me because I didn't have nothing. I was trying to make a living. And I had old lawyers telling me at that time, you can't do this, you can't do that, because you can't do it. Well, my situation was bad. It was different. I'm not saying I did anything illegal or anything, but I tried to win cases, and I wanted to, do things, try to win the case. I didn't do anything I thought was unethical, whatever. But I had lawyers trying to tell me, you can't do this, you can't do that, okay? All these rules and regulations. Well, my situation was bad, all right? So what would I be like if I told you, this is what you need to do because blah, blah, blah. Don't worry about, what about that? Don't worry about that because you can't pay whatever, don't worry about this. Well, yeah, I'd worry about it, that's not, when people tell you that, I mean, that's, situational ethics says your situation to you is unique to you. All right, and for somebody else to come in and tell you this is what you ought to believe, this is what you ought to think, they ain't in your shoes, okay? I think the best thing you can do sometimes is listen. And if there's something you can do to help, then you do that, but you do it with action, not words. Some people tell you, I love you, well, yeah. What you done anything to show me how much you love me? That love is a big word. That love, we'll talk about that too. We'll talk about other things, love and hate and whatever, those big words. Love can be the most dangerous word in the world. Love gets people killed. And like I said, in my 48 years, I've had people, been in the jail cell with somebody, they've shot somebody, their girlfriend, wife, or husband, whatever, and they wasn't dead, and took him to jail on an attempted murder, and I'm in the jail cell with them, they're talking to him, and the investigator comes, knocks on that jail cell, opens up, I go out, and he says, go back and tell your client we're upgrading it to murder because her husband just died, or his wife just died, girlfriend just died. And let me tell you this right here, and I'll shut this thing down for today. But now I'll tell you some more about it. But so many times I've had a guy just start breaking down crying and saying, I loved her so much. I loved her so much. Well, you did, okay? So we'll see, we'll talk about how quick things can happen or whatever, but back to situation ethics. Your situation is unique. And, and if somebody wants to help, they can listen, or if there's something they can do, but with action, then that's where they can help you out. So you've got, that's our, let's do the stakeholders here. Stakeholders include shareholders, employees, supply chain participants. That's in your textbook, kind of out of place there, but that's people that, you got primary and secondary stakeholders. Primary, the people like here that are you have to have them to make your business go. Secondary would be like the bar association for a lawyer. You don't have to have them to succeed, but that's a secondary stakeholder. It wouldn't be somebody you have to keep the business going there. So that's our first lecture, and this is how this thing is going to go. They make these lectures about this long every time, and I'll put the test questions in there throughout the lectures. And like I say, I won't go through all the test questions, but you know how it's going to go, because every lecture I'm going to go through enough where you're going to do good in this class. If you get to the end of this thing and you're not doing good, we'll talk about that, because I want you to learn a little bit of law, and make a good grade. And so we'll hopefully have a good class here, and I'll talk to you next lecture. Thank you so much.